Let's bring in our guest who is standing by, trial attorney Trey Gober, see what he thinks about this expert witness who seems to be changing on several things, even as she's testifying. At one point, she said she's leaning towards anxiety disorder and adjustment disorder, but not even giving a definitive answer, meaning you almost can't know what she's going to say when the jury comes in. Trey, have you ever had an expert witness change their opinion once they get on the stand versus deposition?
Oh, yes, it definitely happens. It happened in the last trial that I had on the other side. This was really, really good work on the part of the defense attorney. And unfortunately, this is something that happens all too often because of the difference of professions, of the precision that we require in the law with our language versus like a mental health professional for this exact witness, Dr. Werner. She's following her standards, and the court, the jury, the judge, the lawyers are expecting consistency as though this is all black and white. In reality, it's more of a gray. The defense has done a great job in establishing this witness and flipping this witness for battered spouse syndrome and really poking holes in her dispute as to the PTSD issue because she didn't get answers to a catch-all question, which seems to be her complaint.
Great point about the different standards in the way that these attorneys versus a psychiatrist is going to be approaching this case. We have to get to that break. Trey, stand by. Coming up, we have more testimony in the Suitcase Murder Trial. The jury is on their way in so they can hear this rebuttal witness. Plus, we'll also bring you an update in the latest in the Burn Pile Murder Trial for defendant Melody Ferris. It seems like this is going to be a difficult witness to get through. Another objection, another sidebar. Let's bring in our trial attorney who's standing by, Trey Gober. Trey, this witness agreed with the defense expert on several points, including that Sarah Boone is not someone who has a narcissistic personality disorder, but that she does display narcissistic traits. She agreed that she had alcohol use disorder. All of those commonalities can sometimes really weigh in favor of the defense, can it not?
Yeah, exactly. This isn't somebody who went out with malice and, to try to hurt and kill this person. There's a combination of factors and underlying conditions and traits that this defendant has that's going to soften the blow if there's a conviction and it gets to the punishment phase.
Yeah, so with this case being a second-degree murder case, we don't know if manslaughter or voluntary manslaughter is going to be on the verdict form. It likely will, but the defense could argue that it not be on the verdict form. Can you think of some reasons why either side may try to keep those lesser included charges off of the verdict sheet for this jury?
Well, the prosecution will want to keep the lesser includeds off so that it doesn't confuse the jury. And if the jury feels that something has happened that was wrong and needs to be righted, the jury will convict. The defense would often want to have a lesser included there to give the jury an opportunity to pick some lesser charge. The jury isn't instructed it's a lesser charge, but to pick one that might be a softer blow to the defendant. However, the defense might opt to not ask for a lesser included charge in this case if they feel like they have enough to get a not guilty on the big charge, the second-degree murder. Then maybe they can walk with a clear, clean, not guilty verdict and not risk a guilty on a lesser included. So there is a significant strategy there to discuss with the defendant.
We'll be paying close attention to it. Trey, stand by. We understand that the jury has been sent out of the courtroom. That means more arguments. We'll get to those after this quick break. Stay with us. You're watching Court TV Live. Let's bring back in trial attorney Trey Gober. Trey, what do you think about this ultimate issue question? Imminent fear. She's opining as to whether or not Sarah Boone felt imminent fear at the moment. Is that to you an ultimate issue in this case that a witness isn't supposed to get into?
It definitely feels like it to me. The judge is a very good judge. He's basing his rulings off of the law. He's not shooting from the hip, so we can't fault the judge at all for his opinions. If that's the law, that's the law, but certainly feels like an ultimate opinion to me when the witness is telling the jury how to fill out the verdict form.
Oh, yeah, I would agree with you on how Judge Koenig has run this courtroom. It has been very measured. He has ruled for the defense at times, for the state at times, and he's always very clear about why he is ruling, how he's ruling. Discovery issues can sometimes derail a case, but in this case, he is keeping it on the rails, and they are continuing to move towards those closing arguments. Trey, this witness, though, we still haven't gotten really a smooth run of hearing from Dr. Werner, and I don't know how much you got to hear from Dr. Julie Harper, who was testifying for the defense, but how would you compare the testimony or just analyze how she's doing on the stand?
This can be a really frustrating process for the jury. A lot of jurors just want this thing to be over with, and they keep having to come in and leave the room, come in and leave the room, get up, sit down, and we're not really moving the ball forward. And so that's going to be really frustrating for a jury, and they can hold accountable the side that they think is slowing it down. If they perceive it's defense objections that can come back to bite the defense. I don't know on this particular case what the jury's going to do, especially given that it's obvious the witness is also being difficult on the stand in answering the questions.
Yeah, I want to ask you more about that, because do you think that she's a difficult witness? We have experts, sometimes there are objections, and it does seem like she has changed a bit in her thinking, but you said that happens. But would you consider her a difficult witness, or is she being asked difficult questions from these attorneys?
It probably depends on which side you're on. My reason for saying that is it seems that she is the type of witness who will go out of her way to expand upon an answer when answering for her side, the prosecution, but she's very limited and reserved and holding back with anything that she's going to provide when answering questions for the defense. For example, during that deposition portion with outside the presence of the jury, instead of just saying, yeah, I think she has BSS, the defense had to ask her and come at it from 3 different angles to get her to finally concede, yeah, I think she has BSS.
Yeah, you are so right. It seemed that she was almost changing as she was being asked, but they got the answer that they wanted on the end. Last question, Trey. It sounds like this witness agrees that Sarah Boone suffered from different things, including battered spouse syndrome, but she's not willing to say that that impacted her on that day. Is that a distinction that the jury is supposed to make?
I think so. That's this ultimate question situation that we're in right now, is what was the precise state of mind of the defendant in that moment. The defense is going to argue once you have a battered spouse syndrome, then it's persistently present. And that's going to be difficult. It's going to be a matter of reading the definition to the jury.
That jury coming back into the courtroom. We'll pick it up right where we're leaving off with the cross of Dr. Tanya Werner. Stay with us.